Good afternoon, everybody. My name is Liam O'Connell. I'm a partner here at Nutter, and thank you all for being here today for this presentation. We hope it to be a discussion presentation, really more of a roundtable, a discussion of moving forward to the new normal and returning to the workplace in light of the Commonwealth's guidance that was released yesterday. So we want to thank you all for joining us. I do want to note at the beginning, if you have any questions, please feel free to submit them online during the presentation. We will try as best we can to respond to any questions that we receive, and to the extent that we can't get to them in the time allotted today, try to follow up with those. We did, those that submit them, we did receive some questions before we started today, so we'll try to address those as well. Let me start with introducing the panel. So as I said, I'm Liam O'Connell, and with us here today are my colleagues Natalie Capilazzo, Emily Grannon-Fox, Chris Lindstrom, and David Rubin. I talked about, we want to talk about the guidance that came out yesterday. If we can, we'll turn the slide. We have a very brief agenda summary that will guide us as we move forward. We'll talk about policies and practices, the physical space of the workplace, what employers will need to be mindful of as they reopen with respect to physical space. We'll talk a bit about testing and tracing and some of the privacy concerns that are implicated there, and then have a discussion about at-risk employees and some of the legal considerations that emanate out of that. So first, by very, very brief overview, you all, I'm sure, have been through the guidance and looked at it in some detail, but as we all know, there's a 4-phase plan for reopening Massachusetts. The phased reopening of businesses began yesterday on the 18th. Businesses that are eligible for and wish to reopen will have to meet certain mandatory workplace safety standards and sector-specific protocols, as well as having a COVID-19 control plan and the posting of several mandatory posters in the workplace. All businesses are going to be required to self-certify before they reopen that they've met their requirements, and that must be done for those that are operating now as essential businesses by May 25th, so they'll be required to do that as well. As I noted, phase 1, which is called the start phase, began yesterday. It allows the resumption of business in the construction industry, manufacturing industry, hospital, health center care for preventive, high-risk, and pediatric patients. Next week, on the 25th, there'll be some additional businesses that will be eligible to reopen if they meet the requirements. Those include retail, remote fulfillment, or curbside pickup environments, office space outside of Boston, laboratory space, hair salons, pet grooming, and car washes. On June 1st, office space within Boston will be eligible for reopening if all requirements are met. As I noted, it's a 4-phase program. The first, the start phase. The second is the cautious phase. Third, vigilant. And the fourth will be the new normal. By the guidance released yesterday, each of those phases will be a minimum of 3 weeks in duration, the possibility that they'll be longer depending on what the statistics tell us by way of the success we're having in controlling the virus. So a couple of the requirements, employers to open will need to develop written COVID-19 control plans. So for those of you that may be eligible to reopen, for example, in phase 1, those are things that you want to be working on immediately. Those will need to outline how the workplace will be constructed and workplace issues addressed to prevent the spread of the virus. And in addition to that, as I've noted, there'll be several mandatory posters that employers will have to post in the workplace. So with that, I would like to get a couple of my colleagues involved in the presentation. I'll start with asking Emily Grannon-Fox of our Labor and Employment Group to talk a little bit about the mandatory safety standards that are part of the phase 1 plan and what they mean for employers that are looking to open, and what that means for employers' policies and practices and physical space.
Thanks, Liam. Hi, everybody. As Liam mentioned, the governor set forth some mandatory safety standards for all businesses that are opening in phase 1. He also put forth safety standards for specific sectors. But as Leah mentioned, each employer has to come up with a plan and put a poster certifying that they've created a plan in a visible place in their building. The attestation is pretty simple. It actually only has 4 things that you have to certify that you've done. That workers are wearing face coverings and social distancing measures are in place, that the employer provides hand washing capabilities and are regularly cleaning and sanitizing high traffic areas, that their workers have been trained in those protocols, and that they've established thorough cleaning and disinfecting protocols. Kind of along those lines, the mandatory safety standards are divided into those 4 categories: social distancing, hygiene protocols, staffing and operations, and cleaning and disinfecting. And beyond that attestation, though, each sector has to kind of develop their own plan based on workspace. So I'm going to talk a little bit about how employers can meet those requirements based on their workspace and physical issues. So when you're assessing your office, you know, to meet the requirements of maintaining the 6 feet of social distance, you're going to have to, especially in an open floor plan, make sure that the workspaces are at least 6 feet apart. So that might mean, you know, if you have individual offices, that might already be met, but if you have an open floor plan, you're going to want to move the desks a safe distance apart. If you're unable to do that, the regulations state that you have to put up physical barriers like the plexiglass barriers that you see at the supermarket. Let's see, what else? Other recommended best practices are establishing one-way traffic in hallways, designating certain exit and entryways to limit traffic at either of those places, assigning workers to specific areas in the building, whether it be a certain area of the floor, a certain floor. For example, one team on one floor to minimize movement through the facility. A big one is common areas. So what do you do about a cafeteria or a conference space or a lobby? Employers are going to have to look at that, and to limit the density in those areas, you may have to eliminate access to those areas entirely, or make sure that employees can see visually how far apart they need to stay. For example, the distance markers that you see in the stores might need to be placed, for example, in a lobby towards the elevator, in a cafeteria, in a building. Cafeterias have their own set of rules. They can only sell prepackaged food now. Let's see, it's recommended to remove access to shared amenities such as coffee pots or water bubblers. And all of this, it's recommended that employers put up visual signs such as the distance markers, signs reminding employees to wear masks, and practice proper hand hygiene. Kind of along with that, the cleanliness factor here, employers are going to want to make sure that there's sufficient hand sanitizer, soap, tissues, touch-free trash cans, that sort of thing, with signage to remind employees to practice proper hygiene while they're in the office. Along those lines, you know, employers are going to want to make sure that they do more frequent cleanings, that they frequently clean high traffic areas, that they minimize contact with high traffic office equipment, such as copy machines, and in areas where there's going to be a lot of congestion, like an elevator bank, the governor's recommended that only one individual go into an elevator at a time, and that, of course, everyone wear masks in that situation. And I think my colleague David Rubin is going to talk a little bit about scheduling.
Yes, thank you, Emily. one thing I just want to note again is that the governor's orders that have come down have very specific guidelines for different sectors. So that and we're talking mostly here about the office guidelines, but they are distinct from those for laboratories and those from manufacturers, et cetera. So we're focused here largely on the office ones because I think they're the most restrictive and in some ways probably the most difficult to navigate. And I think the most fundamentally important one of the restrictions on reopening offices is that the office capacity is limited to 25% of what its maximum occupancy is, or what the employer was operating at in terms of occupancy as of March 1. Doesn't say it has to be the lesser or the greater of. It says that essentially you have a choice. You can use either of those numbers, but it means you're going to be operating at 25% capacity. So one way of dealing with that, obviously, is to schedule people in shifts, have people come in overlapping shifts so that there's never more than 25% of your workforce there as possible. To the extent that employees can telework, they must. That's still the rule. And which in terms of an office environment, obviously, is the most common, is the place where it's most likely to happen. In terms of scheduling, you're supposed to schedule your lunch periods as a staggered way, your start and ending times in a staggered way, meetings, any different aspect of the workday is intended to be scheduled in such a way that that you're minimizing the number of people present at any given time. And the policy surrounding that could be built into your COVID plan and part of your control plan. One other piece of this that I think will come up, repeatedly. I know that we'll be talking about this, as we go forward in this presentation, is that in terms of how you bring people back, who you're going to bring back and when. That's a process I think you're going to need to follow, and I don't know why I'm getting that whistling, but I think that's a process that's going to be very similar to a layoff process, but just in reverse. How you go through that selection of employees who are going to come back and when is going to take a fairly careful analysis. You want to ensure that you're navigating all of the relevant discrimination rules and other requirements. So with that point, I'm going to turn it back to Liam and we'll move forward. Thanks.
Okay, thank you, David. One note, Emily raised this, but I think it's worthy of repeat for all of us to be mindful of. And David touched on this. We have the mandatory safety standards that will be applicable across the board to all employers, but there will be sector specific and are sector specific. So for example, if you look at what was released yesterday for the construction industry as an example, there's very specific requirements for that industry that obviously would not be applicable in the office environment. Startup meetings and the rest, use of vehicles, no more than one person traveling to site in a vehicle, et cetera, right? So depending on the industry that you may be operating in, you want to be sure that you're addressing both the mandatory safety standards across the board as well as the sector specific standards. We're going to move on to another area that what was released yesterday in the guidance implicates, but beyond that, even employers making plans to return to the workplace, and even those employers that are presently operating as essential services have been dealing with the issue of what can we and what should we be doing by way of testing or tracing employees, and then what are the privacy concerns that arise from those steps that we might be taking. So I'm going to ask my colleague Natalie Capilazzo to address some of those issues, what we've been seeing employers dealing with in that area.
Thank you, Liam. So just to start, I think as employers are starting to figure out moving forward and recalling employees back to work, obviously testing has been a big issue. So in the first instance, what are employers allowed to do with regard to testing? So first, employers are allowed to administer COVID-19 tests. Employers are allowed to take employee temperatures, and employers are also allowed to ask employees questions specific to COVID-19, such as whether the employee has had COVID-19, has had symptoms of COVID-19, has been tested, or has come into contact with anyone who's been diagnosed positive. And then fourth, employers may ask employees to self-report symptoms and/or test results. And then just a few notes on that and some of the issues that testing presents. Employers should apply whatever practices they implement with regard to testing uniformly and without any regard to protected characteristics. So for example, age, pregnancy status, other characteristics. For example, an employer would not be permitted to administer tests only to employees age 65 and above, even though that has been identified as a high-risk category by the CDC. So employers should just keep in mind that they should administer all of these practices uniformly. And then if an employee does have COVID-19 or symptoms, the employer may prevent the employee from entering the workplace because the EEOC has made clear that an employee with a positive diagnosis presents a direct threat to the health and safety of other employees. Similarly, if an employee refuses to allow the company to do a temperature check, or if the employee refuses to answer those questions about COVID-19, the employer again can bar the employee from coming to work because of that direct threat acknowledgement by the EEOC. And then with that, I just would move into a note on tracing. Obviously, this is something that employers will likely start to implement moving forward, but just a few points on that. The employer should designate a representative to be responsible for interviewing employees to learn who they came in contact with. And ideally, this person should be a manager, supervisor, someone from human resources, and that information should be contained to as few people as possible, and bearing in mind confidentiality requirements, which I'll address separately. But again, that person who's responsible for interacting with the employees should take action to notify other employees of potential exposure, bearing in mind that they should only reveal the amount of detail necessary for the other employees to assess their risk. And the important takeaway here is that the EEOC has made clear that an employer is not permitted to reveal the identity of the positive employee. And there is an understanding that this might get a bit tricky in situations where it's a very small number of employees that you're dealing with. For instance, if the employer says someone on this floor tested positive, if there are only a handful of employees on that floor, the other employees might be able to guess who the positive employee is. But again, just a word of caution, in that instance, the employer still cannot confirm the identity of the employee if asked. And then with that, I just would move into the question of privacy and confidentiality. So per the EEOC, all medical information about employees must be treated as confidential. Medical information must be maintained separately from personnel records and kept on separate forms. So this applies to temperature testing. The employer should keep a log separate from other personnel information. And medical information can only be disclosed to supervisors or managers who are implementing work restrictions or reasonable accommodations. Second, first aid and safety personnel. And third, government officials investigating ADA compliance. So that's sort of the rundown in terms of testing, tracing, and then some of the privacy concerns and confidentiality issues that have come up around those areas. So with that, I would turn it back to Liam.
Okay, thank you, Natalie. So I'll ask Natalie, as well as my other colleagues, maybe address a couple of questions that we have received from employers that are either already doing some form of testing and or are considering a form of testing, because it raises some interesting FLSA wage and hour type issues, right? So employees showing up for work, waiting online to have a temperature taken, is that going to be paid time? What do we do with the employee who maybe comes to work and actually does have a temperature such that we're sending them home? And how is that going to be handled under both state and federal law? So I'd ask Natalie if you have any thoughts on that, Emily and David maybe.
Sure. So thanks, Liam. The short answer is that this will probably vary state to state and by jurisdiction. But the question sort of boils down to whether that time spent waiting to be tested or getting a test or a temperature check is a preliminary activity, or which is not compensable, or a principal activity, which is compensable. The conservative approach would obviously be to pay non-exempt employees for time spent testing. Another option is requiring employees to do those temperature checks at home, which would take less time, and then the employer doesn't necessarily have to then deal with the issue of sending employees home or facing the dilemma of report to work pay. But there are sort of a few options, and that's, again, going to depend jurisdiction by jurisdiction, but curious to see what others think.
Yeah, Liam, I would just add to that. Natalie mentioned the reporting to work pay. There's an old sort of obscure regulation in Massachusetts that says anyone that shows up to work is guaranteed at least 3 hours pay. You know, I would think someone's going to try to invoke that, right? If they come in,
Right.
they test positive and get sent home. I think that's likely to come up.
I think kind of to expand on that a little bit, there's among ourselves, we were discussing whether that time would be kind of considered donning and doffing time, or which would be compensable, or waiting to don and doff time, which is not compensable. And I think that's kind of going to be the question state to state. Certain states like California have, California has a work order that says when you're under the control of the employer, that time is compensable, but not all states have something like that. So I think it may vary.
Yeah, so there'll be some interesting issues that we suspect as this plays out. The best corollary I could draw is we dealt with some of these kinds of questions in the context of when employers started implementing various security measures, the post 9/11 era and then beyond, particularly at those type of locations that present more hazardous conditions, right? And perhaps we're more concerned about threats. And so you'd have situations where employees would be waiting online to get through security before entering work. And these kinds of cases arose in the context of that. So we'll see how that plays out. Some of this obviously be dependent upon the physical landscape of the employer's premises and how you might best handle those issues. A lot of employers are thinking about, well, how do I do these tests if I want to do them third party? Do I hire a third party to conduct these temperature checks, right? What kind of equipment do we use to do that? What's the technology that's used in the rest? So as that plays out, I suspect that there'll be some issues that are specific to the employer and their operations.
Liam, I did also want to mention that there are other options other than the temperature checking that a lot of employers are considering, because some people are worried about the unreliability of temperature checks. There's also the invasiveness of it, and so there are some employers out there who are thinking about including some sort of attestation form where the employee, every week or maybe even every day, signs something that says I don't have symptoms, I've not been exposed, things like that. Of course, you're relying on honesty of your employees on that one. But there are some less invasive options that employers are thinking about too. So no one should think that that's the only that you have to be doing temperature checks. Although in some industries, in some office spaces, in some places, it's definitely the best way to go.
Yeah, it's an excellent point, Chris. And in fact, the EEOC has addressed some of this with some of the non-FDA approved type testing that goes beyond temperature testing that some employers might be able to make use of. And as it relates to the Commonwealth, if you look, for example, at the construction industry-specific guidelines that were issued yesterday. They have a zero tolerance policy on sickness in the work area, right? So some of the attestation that's individual to the employee that Chris referred to is going to be front and center for some employers. As we bring people back, though, beyond the testing and tracing issues and the privacy concerns that Natalie's touched on, are other issues. If you look at the guidelines and the concerns that employers will have with those folks who are most at risk, the vulnerable populations or the at-risk employees, there'll be concerns about how we bring those employees back to work and how we deal with the anti-discrimination laws and our obligations as employers with respect to that. So with that, I'm going to ask my colleague Chris Lindstrom maybe to address some of the issues that we see employers working through right now on that front.
All right, thanks, Liam, and I hope everyone out there is doing well. It's, you know, as employers, everyone wants to protect your employees and implement policies and procedures that are going to offer the greatest protection, especially for those members of our population who are most vulnerable to COVID-19. And, you know, when I speak of vulnerable populations, I'm thinking of those individuals who are over 65, or those individuals who have certain medical conditions that make them more susceptible to serious illness or even death if they have a COVID-19 exposure and then illness. And so, you know, in speaking with clients over the last couple of weeks, I've had some people who have asked, well, what if I just institute a policy that says anyone over 65 in my workforce, you can't come into the office for the next 3 months? What about a blanket bar? And the guidance out there is pretty clear that you cannot do this. You cannot tell everyone on a wholesale basis that's over 65 or has certain medical conditions that they have to work at home or they have to stay at home. What you have to do is take an individualized approach, much the same way that you take an individualized approach in our old world of dealing with FMLA, ADA, disability situations. And so that starts with letting people self-identify if they have an issue. So a lot of employers are thinking about sending out a direct communication to, you know, all of the employees who are coming back at a certain time. And you may include your policies and procedures, what you're going to adopt, some of the things Emily and David were mentioning earlier. And within this communication, tell people if they have concerns about their specific situation or specific medical conditions, they should reach out to HR. And once this happens, then you will be able to do that, you know, the interactive and the dialogue with people to understand what their situation is. And the bottom line is that it's likely going to be that the best option for someone who's over 65 or someone who has a pre-existing condition, that they should continue to stay at home if possible and work at home. And that's particularly true now that we have federal and state guidance that makes it clear that they want these populations to stay at home. You know, you have, even in the federal Opening Up America guidelines, it states that you know, it strongly encourages employers to provide special accommodations during phase 1 and 2. You have the governor's 4-phase reopening plan, which says that there should be priority consideration for workplace accommodations for these vulnerable populations during the first 3 phases of the reopening plan. And remember that the first 3 phases are going to last us at least 2 months, if not longer, as Lee mentioned earlier. And then finally, you have the Massachusetts Safe at Home Advisory, which encourages these vulnerable populations to stay at home unless they need to go to the grocery store or some sort of essential a need for their well-being. And so in these initial few months, the best practice is clearly going to be to offer stay-at-home work where possible to any employee in a vulnerable population. Now you're going to have, as I mentioned in the beginning, each one of these situations, each employee is going to have to be considered individually, their circumstances, and you could very well have, you know, that 80-year-old employee who wants to come into work and says, you know, I'm not worried, I want to come into work, you can't stop me, basically. And that's true that unless it's an extreme circumstance, where there's a substantial risk, you can't prevent this person from coming into work. But you should engage in that dialogue and try to have other accommodations, such as a different work shifts, something like that, to help them out. But if the other question a lot of employers are going to confront, and especially those who have been in the essential services over the past few months, is what if work from home is not available for an employee with a pre-existing heart condition or who is over 65? And again, you're going to have to kind of take that ADA approach of figuring out what other accommodations are available. And maybe that's a temporary leave of absence. Maybe it's shifting responsibilities temporarily to something else where it can be accomplished from home. So it's going to be a pretty tricky situation for all employers and bringing everyone back. Much more difficult than sending everyone home, unfortunately.
So Chris, what about the, as we reopen, or as employers potentially have been closed and reopening, what do we anticipate? What do you see for the, how to handle the employees that come to the employer and say, look, I'm not comfortable coming back. I don't want to come back. I'm concerned about my own health, or I'm concerned about the health of some folks that I live with. I live with my parents, or I have older in-laws, or whatever it might be. How do we handle that kind of feedback from employees?
Yeah, no, it's going to be a really difficult situation, especially where it's a subjective fear. Again, I'm going to point back to the last couple months. The essential businesses that have remained open have had this problem a lot, and especially as we're learning more and more about COVID-19 and what was happening with it. If there is no specific health condition, then you could take disciplinary action such as termination, but you have to be careful. There could be specific circumstances where there is a mental health condition, PTSD, something like that, where it is where you should be providing an accommodation. And so it's going to be a tricky situation.
And I'll add, in addition to that, David, maybe you can address this, but whether one is in a unionized environment or not, there are certain rights employees have under the NLRA, the National Labor Relations Act, to engage in concerted activity in the context of a group of employees being uncomfortable returning to work. That creates some issues, right?
Oh, absolutely. There's a provision in the NLRA that says employees can refuse to work when they have a reasonable basis to believe that it's an unreasonably threatening or dangerous work environment. I'm sure that will be invoked somewhere. It raises the point, Liam, that virtually all of the things we've talked about for the last half hour or so, for those companies that have a unionized workforce, that's a whole other layer of issues to navigate, laws to navigate, and obligations to have to work through, because the union has to be brought in on virtually all of these decision processes.
Yeah, things like recall rights, right? If people have been out of work and are now coming back, the whole process by which those individuals come back, as you said, the inverse of a layoff in the union environment, is either governed explicitly by a CBA, or if the CBA is silent on how that gets done, it's mandatory subject to bargaining. So we did get some questions that relate to, and Natalie touched on this a bit, but Natalie, directly a question as to whether employers can require, as a condition of coming back to work, all employees to submit to a temperature test or a virus test of some sort.
Yes, the EEOC has made clear that employers may require testing as a precondition to returning to work. At first, the EEOC's guidance made clear that temperature checks and simply asking employees questions about their symptoms and potential exposure were permissible, but since the EEOC has also made clear that administering COVID tests themselves is also allowed. And again, if an employee doesn't comply, refuses to answer questions, refuses the temperature check, the employer can permissibly prohibit that employee from coming back into the workplace.
Question about different approaches employers might use to deal with the issues that Chris has raised, which are perhaps you've got an employee population that that has a good number of older workers who may be at risk or vulnerable. Chris talked about the individual approach to each of those employees and trying to work through a best approach, either by way of accommodating in the workplace environment so that the risk is diminished, and or leave policies and the rest. David, can you talk maybe a little bit about, we've seen some employers that have actually introduced retirement plans, what we call voluntary separation plans, and the legality of that in offering something for employers if they're getting near a retirement age and might think in this environment that they might want to exit the employer's employment.
Well, to me, that's in some ways a non-COVID question, right? Because the law on offering those kinds of plans is set by the Older Workers Benefits Protection Act. I don't even know how old that is anymore, but you know, there is a special rule that says you can offer a special benefit to employees above a certain age. And it seems to me, so long as you follow those rules in making that offer, that should be okay.
Yep. What about, we've got a question here about an employer that plans to continue to work remotely to the extent that they can, but have concern about, in a sales environment, for example, employees that may need to visit clients in other locations that perhaps are in, further along than Massachusetts in reopening their economies. How do we handle those situations? Emily or Natalie?
Sure. I think that's going to be a case-by-case analysis too. And it, you know, it depends on a lot of things, that where they're traveling to, the level of risk of that person traveling. So, for example, in Georgia, they're up and running. Is Atlanta a hotspot anymore? Where's the meeting going to take place versus a meeting in New York City or New Jersey, you know, where maybe the problem is still very active, and that kind of brings negligence and risk concerns into play. I think the answer is it depends.
We have a question here about the costs of testing, that if an employer is going to require employees to submit to some form of testing before returning to work or as a condition of work, is the employer obligated to bear the cost of that testing? Go ahead, David.
As I recall, and this is another old statute, I think, in Massachusetts, that says an employer that requires an employee to get a medical exam of any kind has to pay for the exam. I'm not sure why that wouldn't apply here.
Yeah, I would agree with that. We have a general question, a couple of questions that relate to liability, something that Emily just touched on. So maybe, David, I'll ask you this, your thoughts on the liability concerns for employers, for employees that might make claims that they have been exposed. For example, those employees we talked about that may be reluctant to come back and have concerns for their well-being. What kind of liability concerns might employers be faced with in returning those people to work in the present environment?
Well, and that's a really hard question, an open issue, but you know, I think we look at it in three different perspectives. One is, you know, workers' comp. You know, if someone claims that they've gotten ill at work, will workers' comp cover it? That's a battle I think that the workers' comp insurers are sort of gearing up for, because they're going to be denying these claims, I believe. And I know there's been some push by legislatures to try to force the comp carriers, the comp insurers to cover claims, and they've been pushing back. So don't know where that stands. So if comp doesn't cover it, then it really comes back to it becomes incumbent on the employer to ensure that it was acted in a non-negligent way in all times, that it complied with all of the state, city, federal requirement, best practices from the CDC, et cetera, so that if it came to that, we'd be in a position to prove that they were not negligent in the way they conducted business.
And of course, those concerns would be very real in the situation where it's not just employees that are on our premises, right? Where we have third-party contractors, for example, visitors to the premises, customers, what have you. There obviously would be no even argument that there's a workers' comp bar there, so it's something to be mindful of.
And
I'll
what
ask this
it's
one.
going to be, you know, in terms of social distancing, is going to be particularly problematic, because what do employers do if it finds that employees, or even worse, vendors or clients or third parties, are not honoring the social distancing rules? And so that's going to be something that you're going to have to make sure your supervisors, your managers are really going to have to enforce with uniformity, at least for these first few phases, right? I could see that becoming a real issue, and ripe for negligence issues if you aren't enforcing it.
Chris or Natalie, maybe I'll ask you to take this one. We have a couple of questions here along the lines of the obligation for employers to inquire of employees, for example, who've been on PTO or had time off, whether they have traveled to locations that might be deemed to be hotspots, or sort of monitor their activities before allowing them to return to work.
So this is interesting, because an employer can make inquiries that are necessary to protect the health of the workforce. But whether that extends to asking employees what they've done on their personal time or where they've been is a little bit trickier. Again, it's a bit of a gray area, but I think that if the employer has some sort of reason to believe that the employee might present a risk to the rest of the workforce, then the employer is justified in asking additional questions, but would be cautious just in case it's getting into that gray area of going beyond what would be necessary to assess the risk.
We've got a couple of questions here that deal with transportation issues, right? Do employers have to subsidize parking if employees normally take public transportation in returning them to work? Anybody want to take that one?
I don't think there's an obligation.
No.
It's a really good question, because a lot of employees are going to say, I don't want to get on the subway, or I don't want to get on the bus. But there's no law protecting them from having to get on the bus or get on the subway.
I would agree with that answer, David. Certainly that's, I've been asked the question more than once. I think that many employers are looking at making those kinds of arrangements for those employees that are returning, particularly given that, for example, in the office environment right now, if you are reopening, you're eligible to, and you're choosing to. And again, it's a choice, right? You're eligible to, you've got to meet the mandatory requirements and the rest. But if you choose to open, you're limited at 25% capacity. So many of those employers, in order to get people to come in, are taking a look at programs by way of subsidizing parking costs, for example, if somebody normally takes public transportation. So, well, we're up against the time here. I just want to see if there's any other questions that have come in here at the end. I think we touched on this during the presentation, but does the 25% refer to the number of employees, or does it refer to the office capacity? I think you touched on that, David.
I think 25%, I believe it refers to the number of individuals allowed to be in the space. Right.
And presumably before COVID-19, you didn't have more employees than are allowed in the maximum occupancy. So you should probably take into account how many employees you usually had in the office, before March 1st. It's the easiest way to do it, I would think.
Right. Okay, well, with that, we're up against the time. We'd be happy to answer any additional questions that might be posed, and we invite you to submit those. And we do thank you very much for attending, and for those of you that are clients that we've dealt with, we appreciate the confidence and trust you've placed in us, and we wish everybody on the call continued health and safety. So thank you very, very much.